Okay, so welcome to Our Health in Europe. We're very happy to start another autumn season here. Today we have Laura Kadile from University of Latvia, who's talking about informed consent for incapacitated patients in Europe. So without further ado, over to Laura. Thank you very much.
Thank you in advance, Mary, and I'm happy to attend this forum already for the second time in 1.5 years' time. And today I can say that I have already submitted my PhD thesis and will share with you some of the research results. And regarding my research and PhD work, that is, I concentrate on assessment of decision-making capacity of patients with limited capacity and introduce Latvia and Latvian regulation with a decision-making capacity as an institute. And today, I would like to start with the introduction and the right to information and right to consent and the framework of these institutes, as well as then move on to the Institute for Decision-Making Capacity, some issues in other EU member states, and as well as assessing this capacity and also related to patients with limited capacity. Let me just start with the introduction that the patient in day-to-day basis and daily basis takes a series of decisions by expressing their will, and such expression of will may be expressed orally as well as in writing, for example, by signing an agreement for entering healthcare institution or giving a permission to before receiving any kind of treatment, test, or examination, etc. And expression of will also may be expressed with activities which explicitly certify the consent. The patients in these day-to-day basis may appear small, vulnerable, and also unprotected in comparison to this whole healthcare system, and in comparison to healthcare practitioner or even a healthcare institution where the patient is at the moment. Yeah, and vulnerable from the point of view that the protection of his rights or legal interests, if his decision-making capacity is limited at the time of decision-making. And in such circumstances, the patient is subject to the will of the health professional or a legal representative, and as to what steps should be taken to carry out the treatment and exercise the patient overall right to health and right to health care. Let's move on to the framework, of course. Just shortly, I will just highlight the most important articles and regulation in the European level and at the international level. So the concept of consent is well known and have been applied since the ancient Egyptian times and Greek times. And it was also used in the Greek medical practice. And international law basically contributed to protection of patient rights and legal interests by assuring these fundamental principles of patient protection, such as right to information and right to consent, as regards to today's presentation. And the right to information and consent to medical treatment is an individual right of patient, and it is well established in international patient rights, as we all, I suppose, know, that a patient's right to give, refuse, and withdraw free and informed consent. When we look at the European level, in European level, member state patient rights, and in particular, right to informed consent, are embedded in individual human rights frameworks. And therefore, first of all, Oviedo Convention, shortly, as we know, a Convention of Human Rights and Biomedicine, states as a general rule that an intervention in this field may only carried out after the person concerned has given a free and informed consent to it. Then there is a EU Charter of Fundamental Rights that protects the right to integrity of all persons and provides in the field of medicine a free and informed consent. And in additional, it is set out in the preamble of the Charter, that every individual has the right to access to information as well as actively participate in taking decisions. And at the international level, of course, we need to highlight the CRPD, or the United Nations Convention on Persons with Disabilities. I shortened it up, Article 5, that adopts the idea basically of a universal legal capacity that everyone, including persons with disabilities, that's the subject of today's presentation, can enjoy a legal capacity on an equal basis with others. Within this adoption of a convention of the rights of persons with disabilities, there has been a fundamental paradigm shift from understanding of disability centered to an approach that respects the full and equal rights of persons with disabilities. It's actually also has been pointed out by World Health Organization as well. So the Oviedo Convention and the current views in health law support the idea that the paternal approach is ignorant and even dismissive of patient rights. And now to the right to take decisions. It's the right to provide informed consent and to take the decision, of course, falls within the principle of self-determination. Yeah, it should be a fundamental right, human right that applies to every field of medicine, and providing the legal basis for a patient-centered care approach in healthcare. And there we come to the term of this presentation that I highlighted also in my abstract, a person-centered care approach. And in decision-making, related to decision-making, person-centered approach is based, first of all, on communication that we all know quite well is a prerequisite for legally valid informed consent, or just a step forward to legally valid consent, and the interaction between a patient, HP, or a health practitioner, clinician, or also family or any other legal representative. Here I also can highlight that the person-centered and integrated healthcare is also a part of the National Development Plan of Latvia, approved by the Cabinet of Ministers the last 2 years, and the next, it's 5 years. Yeah, so of course, I'm not able to share all of the or all of the results that I came across during my PhD, and but I can see that in a number of Western jurisdictions, the legal framework provides that adult individuals who meet certain criteria are able to take decisions. As we all know, consenting to treatment, as well as consent to participate in the research that I'm not going to cover in this presentation. So, of course, for the most part, fully competent adults who are not suffering from impairments have a decision-making capacity in relation to treatment decisions and other decisions in healthcare. But now let's have a glance to the regulation that's in force right now in Latvia. That's first of all, I need to highlight the law on the rights of patients in Latvia that sets out the framework for informed consent and to consent to medical treatment or refusal from it. It's nothing different than, I would say, in most of the EU member states. It's quite similar. I cannot go into detail, but basically it sets out and says that medical treatment shall be permitted if the patient has given informed consent and also has the right to refuse for medical treatment. For your information, I have also gathered my research results regarding the norms that are enforced in other member states in EU. You can look for these and use for your research if it's if you would consider doing that. But I would say that although the specific definition of informed consent may vary from state to state, it is clear that a physician or other medical provider must tell a patient all of the potential benefits, of course, risks, alternatives, and of any medical procedure, of course, or treatment, and must obtain the consent to proceed. Now we are again back to the patient-centered assessment and the term of patient-centered approach or care, and back to the consent that is, of course, legally valid only in the circumstances if a patient has been properly informed and has the capacity to consent. And patient-centered assessment is clinically relevant process that identifies patients' specified conditions and behaviors, and it is not just a general assessment of decision-making capacity, and we need to bear that in mind regarding the information that will follow. But besides that, practice from large healthcare institutions in Latvia actually shows that in many cases, the given sheet of paper, so to say, of written informed consent was not even explained to a patient. And probably there was a research conducted that concludes that the healthcare practitioner did not even meet the patient at the moment. And I found out, this is quite a new research, and the results that I have gathered, I have not had the opportunity to include it also in my PhD, but I put it down. I just put it here for you and found it out that also in Estonia, patient consent plays a little role in decision making. And there have been also circumstances where the patient is not even doesn't know even the name of the clinician. And what else? It is often asked to sign these written consents shortly before surgery, for example, or any manipulation that is carried out. But most probably it will be before a complex surgery that also I've included in my PhD regarding these examples. And also Croatia. In the practice of Croatian healthcare institution, it has been found out that not providing sufficient information, not clarifying terminology, and not allowing the patient to ask the question, which is basically some sort of a paternalism as well. We will speak in a minute. So what it leads, what a conclusion we can make. Basically, it's particularly important for each of us, or if each of us can be in the situation where we lack capacity, and it's not only mental illness. It can be just a stressful situation where we are not able to concentrate and read through this written consent. Yes, informed consent, I mean. So, but it is particularly important for people whose health is temporarily or permanently affected by illness or trauma. Now to my favorite part, and basically the need of such institutes also in Latvia, but as we will see, Latvia is not the only country that misses such an institute as decision-making capacity. When we think about it, and I clearly know that it's well-known and well-established in UK, and you work with that in a day-to-day basis, but basically it's a fundamental and central component, this prerequisite for informed consent, but it is not a concept and term used in Latvian law. And compared to other countries, I'm, again, not able to share all of my research results. But for example, German law recognizes decision-making law. I'm sorry, a decision-making capacity. There's a term for that, Einwilligungsfähigkeit. And decision-making capacity is a form of legal capacity. And when assessing decision-making capacity and compared to the well-known UK system, so to say, where we assess the such elements as understand, retain, use, or weight up system, and the information that is provided to the patient, I just wanted to show you the example from Germany, where you can see that decision-making capacity basically consists of 3 different capacities. They are, yes, indeed, quite similar to the basic system that is enforced in the UK, for example, yeah, that first of all, a patient needs to recognize and understand the meaning, extend the risks of the medical action. The term is Einsichtsfähigkeit. And two more capacities, be able to make and act on a decision on the basis of the information provided. Yes, but in Austria, amendments also in 2018 introduced the legal regulation to the term decision-making capacity, and etc. And here, just also for your information, how this institute is being called in other EU member states. As you can see, the most popular, of course, is still decision-making capacity. But I found out that there's also a term decisional capacity that's basically the same, but the term was different in the legal regulation in Italy, Spain, Portugal. Romania, I found out, maybe it's, I don't know, maybe it's just a misunderstood translation. Yeah, or just not a good translation, but I found out in the official website in Romanian law on the rights of patient that they use a term psychological capacity. And as I mentioned previously, yeah, it is not regulated such institute in Latvia, Slovakia, Lithuania, Estonia, and many more. You can add maybe if you attend here from a EU member state that do not have such a capacity, institute of capacity, you can add more. Then I just wanted to face the situation regarding where we are at the moment. Is there a shift forward, the doctor knows best approach that is no longer applicable in modern medicine? Of course, in most of the cases, we can already see that EU countries, in the EU countries, the relationship between healthcare professionals and patients is built on confidence and cooperation and gratified with person-centered communication. Whereas I have pointed out some I don't know, you can evaluate, is it a good example or not as good, but I just pointed out two examples from the practice in a Croatian healthcare system that is still based on paternalistic doctor-patient relationship, where patient often, yeah, do not even know the name of their specialist, as I mentioned previously, yeah. In addition, paternalism is still present in Spanish medicine in Spain, yeah, that it's worth another presentation, of course, but it's regards to the advanced decision or living will, or which basically patients patients have been saying that they are not willing to prepare such a advanced decision because it's not going to change the attitude of doctor, yeah, or the final decision. And I just highlighted one of the European Court of Human Rights cases held in the case you can see on the presentation, yeah, where basically also it was said that medical treatment, in this case it was a sterilization, carried out by a medical practitioner, forced patient to sign a written informed consent without being able to ask the questions, and even being threatened with the idea that if you're not going to sign it, you will die right after that. Yeah. So, but just one example from many more out there. Now, to the limited decision-making capacity, and bearing in mind everything that I said before, just to open up the discussion, and I would love to hear also your not your practice, but maybe the problems that you face also in your member state, that you can relate what I have been saying. So we can see that data from studies carried out abroad indicate the large number of patients with limited decision-making capacity. There is no data of the prevalence of such patients in Latvia. However, it could be concluded that proportion of patients with limited capacity could be quite similar. Of course, where patient lacks capacity, if there is such an assessment, how to how to validate whether or not the patient is able to take the decision. Yeah, other people will have to make the decisions for them, and it's of course regarding shortly the framework of what I have said previously. Yes, we need to mention and highlight Article 6 of the Convention of Human Rights and Biomedicine, of the Oviedo Convention. Yeah, we need to guarantee the protection of such persons and patients who lack capacity in such moments. But then what I wanted to add, and why maybe there are such differences between implementation of a regulation regards to the assessment or even the Institute of Decision-Making Capacity, is the fact that basically it should therefore be left to the member states to determine the legally designed representatives of incapacitated persons, as well as whether or not persons are capable of consenting to an intervention. Yes, and regards to that, of course, and what I have previously said, there raises a lot of questions. Yeah, what to do when the institute is not regulated in national law? How the capacity should be assessed, and so on. There are a lot of questions that opens up quite a long discussion, and yeah. So, and as I mentioned previously, so if there is no such institute of decision-making capacity in Latvia, yeah, I can additionally say that there's a regulation that states the legal order in case a patient is unable to make a treatment decision, yeah, or a decision in respect to participation in a clinical trial that I'm not going to cover this time. And when we look at the norm and the few, also at the phrase that I have highlighted, we can see that despite this, it is apparent that the patient age is taken into account when assessing their capacity. And yeah, so the norm states basically that the patient if the patient is unable to make decision himself or herself due to his or her state of health or age, it gives the decision rights to a person authorized by the patient or the trustee. This is quite new before the amendments that are enforced now. This is a quite new norm, so to say. And before that, the first person was a spouse of a patient that give the decision rights, in order in the situation where the patient was lacking the capacity. So therefore, it should therefore be noted, firstly, that age, external physical state of health, and disability and patient's behavior are not in line with Article 5 of the CRPD. And so, as this norm of law of the right of patients in Latvia as well. The age, of course, of the person should undoubtedly be taken into account. Yes, but what else can be concluded? If the patient lacks capacity, all cases of those who I'm aware of and I've researched, the legal regulations of other EU member states, where a legal representative makes a decision about treatment or refusal of treatment, the patient's previously expressed a will regarding the treatment is respected, and that's a common practice, and also is enforced in Latvia and can be found in the legal regulation in Latvia. But where we can see the difference is, if there is no one with legal power, then is it the clinician who decides, or who is the person who decides, and whether or not we need to follow each country's legislation, bearing in mind what I have been saying previously. In UK, it would be, I suppose, treating clinician plus the best interests need to be taken into account, the principle of best interests. In Latvia, I've just highlighted a few examples that are quite interesting. There's a remnant, so to say, of Soviet Union. Why? Because the decision is taken by a doctor's council. This time I again do not know if it's just a bad translation, but I found out, and it is written in the official translation of law on the rights of a patient. It should be the same as it's also written in the regulation Estonia, Concilium of Doctors. Yeah. In Germany, it is also quite recently I found out. I attended guardianship days last week, and I was discussing together with professors whether or not clinician really understands from a lawyer's perspective how to carry out the assessment. And the professor said to me and answered that it's still open for even a PhD to open up this question. So it's quite a large discussion, and not only in Latvia, as you can see, but as well as in Germany. One more one more thing that I want to point out is also there are also countries where relatives do not have the legal right to decide on behalf of patients without decision-making capacity. That's, for example, in Denmark, and I suppose it's the same in regulation in UK. If I'm not right, please correct me afterwards. But we can see that the one aspect that varies significantly, yeah, from country to country, relates to the role and responsibilities of the person appointed to represent the patient. And maybe here we can see that it's basically in the line with the previous set out legal regulation. Yeah. And last but not least, yes, I want to point out that the human rights approach and the overall patient-centered care requires to ensure, undoubtedly ensure that the persons with disabilities or with limited capacity can enjoy the rights to consent without any discrimination, and including during pandemics. And I also wanted to point out just only quickly, this is the last slide of the presentation, I'm very interested into this topic. I have been also included a chapter in my PhD regarding COVID-19 and right to consent. Because gaining consent from COVID-19 patients may be difficult because they are obviously in pain. And when we look at the intensive care units, it's worse. And it's very complicated to gain consent and assess decision-making capacity from such patients. Plus, we need to take into account the usage of personal protective equipment that is crucial for this communication. That's the foundation for the informed consent. Yeah, and of course, in order, it was necessary for prevention, and still is. Yeah, and also not during COVID-19, but maybe in other pandemics in the future. But it created a barrier. And therefore, in the circumstances where decision-making capacity of the patient with limited capacity, or the patient capacity is limited, it is necessary to provide a special protection for patients, and especially during pandemic. And for the conclusions, I must highlight that we can see that the EU member states, pretty much strive to comply these binding international European law norms, and but the assessment of decision-making capacity has the potential to be discriminatorily applied to people with limited capacity, leaving a permanent fingerprint of the paternalistic approach. And in circumstances where such practices are in place and certain legal provisions are enforced, there is no move towards a patient-centered approach that is core of modern healthcare law. Of course, the absence of decision-making institution may lead to the violation of the right to free and informed consent, Yeah, and especially if the assessment is based solely on the patient's age, physical state, health, behavior. And this results in a situation, for example, in Latvia, which informed consent or refusal of treatment in whole or in part is obtained in principle by avoiding this fundamental institute and maybe not allowing a patient who has this capacity to consent and vice versa. Thank you for your attention. These are my contacts, and I'm open for any contribution. And if you are willing to know the regulation of the legal regulation in Latvia, and from Latvian perspective, I'm open to work also in research projects. And please contact me if you are willing to. So, thank you. Now I'll stop sharing the screen.
Okay, thank you very much, Laura, for a very interesting presentation, and congratulations on your PhD as well. I'll just stop the recording now.